Supreme Court. We said that you can't make us do units from 1999 to going forward because you can't go back in time and fix the market problems associated with 1999, 2000. In other words, that ship has already sailed, the market can't absorb what it's already lost. But the Supreme Court, being the Supreme Court, said, no, you're wrong, and actually rewrote the Fair Housing Act pretty much to make us do that as well. So that compounded the problem. And then we went to a numbers trial in front of Judge Jacobson, and that's where the number you'll hear us talk about. You heard us refer to 786. That's a product of a 41-day trial in Mercer County. That's your round 3 obligation. And because of the Supreme Court ruling in 2015, we were forced to use population models that were demonstrably inflated by probably the tune of 30%. They were over projected population for the last few decades. So those were the parameters, those were the ground rules, everything was stacked against towns, and it's percolated down to you guys. In your particular case, we've been fighting for 3 or 4 years about the number and how it's applied and where it goes and everything else, and that's culminated in this settlement agreement. Your round 3 allocation was 786, and we said, Judge, we don't have enough land for 786. So what happens then, you get what's called a vacant land adjustment. That's often very, very hotly contested. And the more litigants that are in your case, the more complicated that becomes. We were ultimately able to settle with fair share on an RDP, or realistic development potential, which is your adjusted number of 138. So you're saying, Judge, I don't have the land to do 786, but I do have the land to do 138. So you'll have 3 components, well, really 4 components of your obligation. You'll have rehab, which is just dilapidated units in town that you got to fix up. People don't usually get too upset about that one. Then there's the prior round, that's 262, that was established by COA, that's not in dispute. And then your round 3, once again, was 786, but that's now broken down to 138 realistic development potential, and then the portion that's lost is called unmet need, and that's a different category. There's a lesser standard to unmet need. You typically do overlay zones and stuff like that to account for your unmet need. You have a hard and fast obligation with respect to the 138, however. You have to produce that number between now and 2025, and you have to finish your prior round obligation between now and 2025.
And we will do that.
So that's ultimately the background, and that's the nature of the agreement. Ultimately, it is a very favorable settlement when you consider that had you not had that vacant land defense and you hadn't had good experts like Darlene getting you a favorable number on that, your exposure could have been significantly higher. I represent municipalities that aren't lucky enough to have vacant land problems and have larger numbers than 800, and you can imagine what those settlements end up looking like.
And let me also emphasize one thing for those that are here, that are living in affordable housing and low and moderate income units. We're not against the low and moderate income units. That's our obligation as a community, as a caring community, because the state and the courts have ordered us to do that. We will do that and welcome them into our township with open arms. I'm sure that they'll be part of our community, that they'll wind up volunteering for our fire department, maybe our first aid squad. The problem always was the 4,000 units that goes with that. And I assure you that when it happens, that the units are built, they will be class units. It will not be a slum. That's the reason we're fighting in court. Okay, it's open to the public.